Hello, I'm Vince White. I'm an employment attorney, and I'm answering publicly posted questions on Avo.com, getting people the answers they need from an employment attorney. All right, so we have a question here. Can my employer lay me off after they deemed me unable to do the job I was doing that I've worked at for 23 months? I work at a hospital in the EVS department. I got hurt on the job, and the PQME deemed me incapable of working in the EVS department anymore. They're claiming there are no other available positions for me at the hospital at this time, possibly ever. So, they want to make a modified duty position for me that I've been working as a temporary position. Temperature screener, right? During COVID, everybody's got a little person with the temperature, the thermometer, zapper, and they zap your forehead and they screen your temperature, right? So I assume that's what this job is. After COVID, I will be laid off or they will lay me off now. Okay. So down below this question, Neil Pedersen answered your question. He brought up some really good points. He's a great attorney. Highly recommend him. And I love seeing him take the time to answer people's questions. I think it's so important, right? He said, listen, your question is one that falls into two distinct practice areas: workers' compensation and employment. Now, he's completely right. And I cannot answer the workers' compensation portion of this question. I'm just not the right fellow to do it. You're going to find incredible workers' compensation attorneys out there who can answer this for you. Whoever she or he might be, I hope they answer it on the website. Maybe you can call them up locally, whatever's better for you. Now, let's go to the employment side of this, the employment disability discrimination, right? They owe you, under federal law, a reasonable accommodation. We're not even going to get into what they might owe you under local law. I'm only going to touch on federal law, because that's really all I'm qualified to touch on here. Now, the Americans with Disabilities Act requires them to engage in two things. One, they owe you a reasonable accommodation dialogue. They have to talk with you about what you need and whether or not they can reasonably do it. Great. I'm not sure they lived up to that here based on your question. The devil's going to be in the details. You need to talk this out with an employment attorney. But here, it kind of just seems like they said, yeah, you can't do your job anymore. We got nothing for you. You can take this thing or you can get out, right? That's probably not going to fly. That's not going to be enough, in my opinion. Now, the second part of that is, even if they do give you the reasonable accommodation dialogue, they might come to you and say, hey, we did the full dialogue. I think you would agree. We did a great job. We looked at everything. We really made, every attempt to work this out. We just don't think there is a reasonable accommodation that we can give you. Well, even then, they've complied with the first half of the law, but they could be wrong, right? There's lots of employers. The world is full of employers who say, hey, I can't do that for you. That accommodation is not reasonable. Okay, that's your call. I can go find a judge or a jury who might not agree with you. Do you want to see if they agree with you about this? And a lot of employers don't want to see if the judge agrees, or they're a little bolder and they do. They want to see if the judge agrees, and they find out, maybe the judge or the jury, they didn't agree. They did not agree. And now you have yourself a claim, right? A claim for disability discrimination. So, you need to talk. This is a really long way of saying you need to talk to a local employment attorney about the disability discrimination aspect of your situation. You also need to talk with a local workers' compensation attorney. You could be due funds. I don't know. That being said, back to the area I actually do know about, call up a local employment attorney, have a free consult. Do not. I'm always very nervous about any employment attorney who wants to charge for her or his consult. That makes me nervous because your case is an opportunity for us, right? If we win your case, presumably we win you money, of which we take a percentage. Why would I charge you to hear you out when my job entails me making money only by helping you? Right? So, why would you have to pay just to speak with me? That makes me uncomfortable. I hope that makes you uncomfortable too. I would suggest scheduling 2 or 3 free consultations with local employment attorneys, getting to the bottom of this. Okay? I hope this helps. I wish you the best of luck. If you have follow-up questions, I can only answer under the federal laws. I can really only help you in the EEOC in California, right? That being said, happy to do it. And if you feel like I helped you, well, consider liking and subscribing. That helps me help more people just like you, and gives my message a little bit more reach. And also lets me get more questions so I can help more people, right? Good luck. And I hope this works out.